SJC-11623, Commonwealth v. Walter Thompson.
Please proceed.
Good morning, Matthew Harper Nixon on behalf of Mr. Thompson. The primary issue in this case is whether Mr. Thompson, or excuse me, whether the Commonwealth presented sufficient evidence for the jury to find beyond a reasonable doubt that Mr. Thompson distributed drugs, namely to Lori Quigley, the person he was accused of having interaction with. The Commonwealth presented a chain of circumstances that it asked the jury to decide led to a proof beyond a reasonable doubt that he passed drugs to her and received money in exchange for those drugs. There were a number of factors that the Commonwealth presented, all of which have substantial problems in terms of sufficiency of the evidence. The first issue that the Commonwealth had to address was the fact that, in fact, there was a third party involved, Mr. Benoit, who was holding the drugs when the police came upon Ms. Quigley and him. They were seen to be interacting in a parking lot of a convenience store before Mr. Thompson ever arrived on the scene, counting change. And the expert witness put on by the Commonwealth testified that this type of interaction could be a pooling of money, the use of street-level drug users combining their cash to come up with enough money to make a purchase of drugs. The problem, though, was that was the last anyone ever heard of this change. It was never testified that it was found on Mr. Thompson when he was arrested. There was no testimony as to either of them having it at the time they were arrested. No testimony of them exchanging it for some sort of folding currency that was found in Mr. Thompson's possession. And so this pooling of the money, which was as I see it, the primary explanation for why he was holding the drugs and not her, in other words, they were making a joint purchase of the drugs, was sort of left out into the ether at that point. The next inference they asked the jury to make was that when she left this conclave and made a phone call, he arrived as a result of that phone call. I don't think that the issue at all was with the inference that she made the phone call. The question was, is his arrival on the scene shortly thereafter mere coincidence, or is it a reasonable inference to make that she made that phone call and he arrived to essentially effectuate a delivery of drugs? He was on call to make a sale was the implication. My argument is that the time proximity and their looking at each other as he rides through the parking lot was not enough. But if it was enough, it creates a further problem for the Commonwealth in terms of its proof, because at first the argument was this was a sale of $40 worth of cocaine for $40. He was found in possession of two folds of currency, one of 40, one of 45. That was the opening statement made by the prosecutor. Throughout the course of the trial, once the amount of drugs came into question, it becomes clear that it's at most $20 worth of drugs, possibly 10, depending on which math you take into account. And so the question we have then is, how is it possible that someone who is on call to make a sale would risk that relationship by producing so far less drugs than was passed to him in terms of cash? It's an underground economy, and there was testimony as to burn bags. And so oftentimes a buyer or a seller will shortchange the other party because there's nowhere to go. I think Detective Hyde said you can't call the Attorney General's office. But is it reasonable for the jury to make the inference that someone who's on call to make a delivery would risk that relationship with such a tremendous shortchanging of $40 to 20 or 10? It's an underground economy, but it's still an economy, and at some point, is it reasonable for a jury to make that inference? I think that the confluence of these inferences and the problems with the Commonwealth's case lead at least equally to the notion that Mr. Benoit was selling her drugs. She needed money. She was short on funds. After they did this counting of change, it came to her attention that she didn't have enough money to buy drugs. She either calls Mr. Thompson or sees him on the street and gets something from him to effectuate the purchase of drugs. He rides off and is caught up in the issue. And so I'd ask the court to find that the Commonwealth did not get over the rail, as it were, as to this particular issue in terms of the sufficiency of the evidence. If the court does decide that, I'm asking the court to expand the Bradley case decided earlier this year, or excuse me, late last year, and find that for defendants situated such as Mr. Thompson, where his case, although it was tried, a conviction entered, and he was sentenced before the law changed in August of 2012, his case was still pending on appeal at the time the law changed, and therefore not final for other appellate review purposes. I think that the issues brought forth in Bradley that the court discussed, I think appropriately in terms of the disparate impact of this school zone statute, are exactly the same here in terms of the facts of the case. This was allegedly a sale between 2 or 3 adults at approximately 10 o'clock at night on July 31st in a mixed residential commercial area of Cambridge. I don't think that there's any implication that there were school children involved. It was a park. It was some nuisance to the schools.
But one major difference between this case and, or these cases of this category versus the Bradley cases is that under Bradley, no case would need to be retried. But if you are correct, every case that was tried with a school zone based on the 1,000 feet would need to be retried to determine whether or not it fell within the shorter school zone.
Well, I would argue to the court that, for instance, Mr. Thompson's case would not need to be retried. The Commonwealth had an opportunity to prove a distance from this alleged exchange to the closest school. They selected this international school, German international school. It was approximately 500 feet, slightly under 500 feet from the alleged interaction. And I think from a sufficiency grounds, if it's retroactive, then there's no need to go back and retry that, to give them an opportunity to select some sort of closer school. First, as a logical extension, I'm not sure why the Commonwealth would necessarily pick a school that was further away. It seems to me they would pick the closest school that they could prove was a viable alternative. I would concede that there are probably going to be some cases where there needs to at least be a hearing, maybe a short bench trial as to distance. But based on my 5 years of doing appellate defense work, in every drug case I've seen where there's a school zone issue, there's testimony as to the distance. In this case, there was a map presented. Sometimes you have an officer testifying that he used a measuring wheel, whatever the case may be. But there's some testimony as to how far away this incident was from the border of the closest school within the statute, which makes sense because you want the jury to have that number as opposed to just someone saying, sure, it was within 500 feet. So I don't think that opens up a huge door. That being said, I also, to be blunt, don't have the numbers as to how many cases this would affect in terms of finality on appeal. But I don't think it's a tremendously large number. Mr. Thompson's case took quite a while to make it through the appellate system in terms of getting of the transcripts, getting the case into the appeals court, et cetera. I think it's probably an outlier in terms of the timeframes. But my guess is, if without unfortunately being able to back that up with any specific dates and facts and numbers, that you're looking at a very small number of cases that this would be impacting.
But the issue is really one of legislative intent.
Well, it's whether or not I suppose if the court wanted to make it one of legislative intent, it could. As I read Bradley, the issue was whether the context of the legislation, whether it would be repugnant to not extend the retroactivity of the school zone change to persons in Bradley, situated like those in Bradley and Pagan, persons who are not yet gone to trial. I think it's very clear what the legislature was trying to remedy in terms of the disparity of the impact of the application of the statute. And I would just note, as I've noted in my brief, that many other of the similar changes to the sentencing provisions for drug cases have been applied to people such as Mr. Thompson, people who had already gone to trial, were convicted, and sentenced. And just as an example, he was given a 5-year to 5-and-a-day sentence because it was a subsequent offender charge. He's now parole eligible after 3.5. The DOC has made that determination. I think this court has backed that up. So I think in terms of looking at the scheme of the context of the statute, it would be repugnant not to extend it to Mr. Thompson's case.
In which case, he would be found not guilty.
Yes.
But it could go back for resentencing on the underlying distribution.
I think that conceivably that would be a viable alternative. My understanding is typically these cases there is a consideration by the judge of the from and after sentence, and so I would have to concede that I think that's probably a rational decision to say that it would go back for resentencing.
So pragmatically, if it were 280 feet, the Commonwealth could retry.
I'm sorry, 280 feet? Yes.
But it would not be that an appellate court could say, we find as a matter of fact that it was 280 and therefore we affirm because it turned out not to matter. I mean, would you be asking an appellate court to make that finding?
Well, if it were 280 feet, I'm not sure that even if it were retroactive, it would make a difference. It's still within 300 feet.
Right, but the jury found it was less than 1,000. That's what the
Well, that's
jury's finding
true,
was.
Your Honor. And I suppose I would leave that for another case. I don't, wouldn't want to say for sure that the appellate court could say, absolutely, this is 280 feet. But in situations where it was over the 300 but outside of the 1,000, I think that there's no need to go back and retry the case again.
But inside the 1,000.
I'm sorry, yes. Unless the court has any other questions, I'd rest on the brief.
Thank you, Counsel.
All right, thank you.
Good morning, Mr. Chief Justice, members of the court. Kevin Curtin, Assistant District Attorney for Middlesex on behalf of the Commonwealth, and with me is Jasmine Ali. It is a question of legislative intent on the school zone issue. It was not clearly expressed, and it would not be repugnant to the purpose of the statute, because as Justice Gantz may have been suggesting, the purpose of the statute cannot have been to give everyone convicted of a school zone violation prior to August 1st a new trial. That was not the purpose. That was not clearly expressed, and it's not repugnant to the purpose of the statute not to do that. And it is true that any other method of giving retroactive effect to school zone reductions would require undoing an adjudication of substantive guilt by the jury or fact finder. And the fact that a case is pending on appeal doesn't help the defendant, doesn't change that circumstance. So this is really impossible to do, and it makes no sense under our retroactivity law. It's not just like changing a sentence after the jury has returned a verdict. And as the court stated in Bradley, mindful of this circumstance, a person who committed a school zone violation before August 2nd and pled guilty to that violation before that date will have his case adjudicated under the pre-amendment version of Section 32J.
Pleaded guilty or was found guilty or was convicted.
Or was convicted, correct. Pleaded guilty or correct, or was found guilty.
Or whose conviction was entered.
Conviction was entered is the language of the statute, yes, that's right. Conviction was entered. And here, the defendant's conviction was entered in March of 2011.
Do you have any, there's no reason you should, but I'm just wondering whether you know, just in terms of Middlesex County, how many cases this might affect?
Well, I mean, if you're going to go back.
I mean, I just don't know if somehow you tried to figure that out.
There'd be nothing to prevent it going back forever. If you're going to give new trials to everybody
No,
convicted.
no,
Pending on direct appeal.
yeah,
Pending
pending
on direct
direct
appeal, I
appeal.
don't know. It may be small, because this was this was a long time before everything was ready for the appeal. It could be a small number, but just imagine, the problem is that it's not supportable by law, and it really doesn't make any sense. It can't have been intended. Plus, it's clear, we know that it wasn't intended because the legislature made provision for people like this, saying that people who have had their conviction entered prior to the effective date of the statute can apply for parole, to be considered for parole after having served the reduced minimum mandatory periods of incarceration created by the 2012 amendments.
Well, that wouldn't apply to everybody, though, because if you had a, if you basically had a district court case and your only sentence was 2 years in the House of Correction, I don't know how that's going to
Say
work.
a 1 day with 2 years from and after. So the question would be that, I think at that point in time, wouldn't they be allowed to be considered for parole at an earlier time?
Under the legislation?
Under the legislation?
know.
I think that there may be, I know that there was a paper that was a policy, the Department of Corrections policy has been very liberal in interpreting this statute, and it has not been challenged, to my knowledge, because it's designed to affect the intent of the statute. So I think on the school zone issue, there is not a problem in rejecting the defendant's argument. I would like to take this opportunity to talk about the sufficiency of the evidence and to talk about what I believe is a good opportunity to clarify what I suggest is no difference between Lattimore and the Croft formulation, which was pre-Rules of Procedure, pre-Rule 25, pre-Jackson versus Virginia, pre-Lattimore. The way we thought about it before we had Rule 25, before we had Jackson, and before we had Lattimore, is expressed in the Croft formulation. But we don't need that formulation anymore. That's the idea that if it's at least, if the inference of guilt is at least as consistent as the inference of innocence. You know why we don't need that? And we really should get rid of it because it is a waste of time. The appeals court deals with lots of briefs in which this is argued on all kinds of cases where there's no way it could possibly apply. The Hernandez case cited in my brief, you can see Justice Fecto complaining about it. It's not the only such case. Lattimore talks about conjecture and beyond a reasonable doubt. That's the standard under Lattimore. So, for instance, and you can see the appeals court struggling. In that Cepheus case that the court just recently decided that came up, it was a drug case just a few months ago. And if you look closely at Justice Agnes's analysis in that case, you can just really see the problem. He knows that Croft has not been said to have been explicitly incorporated into the Lattimore standard, even though I think it is. There's nothing that Croft covers that wouldn't be covered under Lattimore. Anything under that circumstance would be conjecture. For instance, if two people engage in a hand-to-hand transaction and both walk in a straight line, along that straight line is then found on the ground later drugs and money, an inference of guilt would be conjecture. It would also be equally probable, but you don't think of it that way because, as an appellate court, and you don't think of it really that way as a trial judge either. Applying the Lattimore standard under these circumstances are concluding that it's been incorporated, that the former conjecture formulation, equally probable, that's conjecture, has been incorporated into the Lattimore standard, would allow the trial court judges and the appellate court judges to apply the same standard. It's a good idea to do it. I think it's been incorporated substantially. It's hard to imagine a case where we're not losing anything by saying that Croft has been incorporated into Lattimore. Lattimore is the sufficient due process standard. And I suggest that this is a good opportunity to clarify that, because we do see a lot of cases in which it's suggested because two inferences are possible from the evidence, the judge should direct a verdict. Very briefly, it may be helpful to the court in deciding.
Facts of this case. Were there toll records indicate that the telephone call was made to the defendant?
No, it was not. However, the telephone call was right after this change, looking at change thing. So I think that the jury was not required to find that looking at change was pooling money for the drugs. Looking at change was preceding the telephone call. But you didn't need to have phone records to the cyclist to infer that the cyclist had distributed drugs, because there are four categories of factors that principally the appeals court have found that will be helpful here that apply. And then there are also a series of factors that are specific to the case. And very quickly, two people in the parking lot known to police office for narcotics, specifically to narcotics, arranging a meeting, anxious and wary. Commonwealth versus Reed, 29 Mass Appeals Court shows that can be a factor. It's not,
I'm sorry.
standing alone, it's
known
nothing.
to the police? Was that was that evidence at trial?
Yeah, they were familiar with that parking lot from prior narcotics.
Okay, so the place was known to be a drug distribution, but I assume there was no evidence that the police knew these individuals to be drug addicts.
There was no such evidence. Okay. So standing alone, not much. But it can be a factor, and it was supported also the anxiety, the pacing back and forth, waiting for the arrival by expert testimony about how buyers have been observed to behave. The defendant arrives on bike, exchanges words with Quigley, doesn't stop, moves quickly 2 houses down, and there's a quick hand-to-hand transaction. Commonwealth versus Soto says that that's a factor that you can consider. The Quigley, after she's arrested, has a glass tube of a type used to smoke cocaine. Now, in Cepheus, there was suggested that the absence of a smoking device on a cellar might have been enough. It didn't have to reach that in the end. May have been an unreasonable inference under Lattimore. We don't know. We didn't have to reach it because of what happened in the redirect on the cross-examination. But here, it's stronger than that. The presence of the glass tube for smoking on the buyer, that creates a reasonable inference that the person with the glass tube, who was also in possession of the drugs, was the buyer. Finally, the defendant has 2 folds of cash, $40 and $45, and Benoit, and the Commonwealth's theory was joint possession, has a twist bag consistent, not the joint possession, but joint venture, Benoit has this twist bag, which is consistent with the packaging of crack, worth $40 to $50. I understand that the evidence was that this amount would not have been $40 to $50, but the packaging was consistent, and that under Commonwealth versus Tanner, that's a factor. Very quickly, specific to this case, you've got factors like when Quigley goes back to Benoit, they go hide behind a fence, the police go behind the house, and they see them standing together looking at the cocaine in the hands. Benoit is opening the bag. When the police announce themselves, they throw it over the fence. All those factors were sufficient for the jury to infer a distribution on the part of the cyclist defendant beyond a reasonable doubt. That sufficient to infer beyond a reasonable doubt standard is the due process standard. We do not need the Croft, no conjecture is permissible, because no conjecture is already incorporated into Lattimore. And for those reasons, Your Honor, I would ask that the court affirm the judgments.
All right, thank you.